Ernie, as we're moving forward with the Dominion class action, I think it's really important that the nation as a whole really understand who you, Ernie, as well as Gary are, as men, as lawyers, and how you came to be in the place that you made the decision you did to take on Dominion and Facebook with this class action. And so if you would humor us with a little bit of your background, where you came from, your childhood, and how you were shaped into who you are.
Sure. Well, I grew up in the great state of Michigan in a small town community in southwest Michigan. St. Joseph and Benton Harbor is the area I'm from. Graduated high school from St. Joseph, Michigan, and went on to join the Navy. Within a week of graduating high school, I was in boot camp in Orlando, Florida, and I was part of the nuclear power program. Spent close to 7 years in the Navy during that time period. Left service as a petty officer first class. While I was in, I earned my bachelor's degree from the unknown college of St. Leo University, which is a small university, but they provide a lot of opportunities for military members to get their education. Went from the military. Before I had even graduated high school, graduated college. I had already decided that I wanted to go to law school. Ended up going to the University of Detroit Mercy. Graduated in 1998. So I've been practicing law now for close to, well, a little over 20 years. I began practice in the Detroit area, kind of doing business defense litigation work. I've pretty much been a litigator most of my career. But once 9/11 happened, I had an opportunity to work at the Pentagon. My former boss, actually while I was in law school, my boss at that time was appointed to be the Army General Counsel. So after 9/11, he called me up and said, "Ernie, would you like to come work for me again?" And I could not pass up that opportunity. So I spent 3 years working at the Pentagon. Had a lot of great opportunities there. Ended up going back to Michigan after that period, working, and took a job with a law firm in the Detroit area, but was really working around the state, working with Indian tribes on various issues, government practice, economic development, casinos, of course. Then I expanded that practice from outside Michigan into nationally, and was representing some tribes around the country, and then settled in Colorado, and where I ultimately left the private practice and went to work again for the government with the Department of Interior. I spent close to 10 years with the Department of Interior, where I was involved primarily in business and labor issues, litigating a lot of civil rights cases, actually, people suing the federal government for civil rights claims, discrimination in the workplace, that sort of thing. So I have had quite a career that extends vast areas. So I have seen and done many, many things in the realm of law, which I think gives me a different perspective on a lot of things. I've seen government on the inside and the outside. I've litigated from both sides, plaintiff and defendant. So I've seen a lot of different things, and I think my skill set and my knowledge and experience is really adapted well for taking on Dominion and others in this case.
Tell us a little bit about when you first started to feel like something was wrong and you needed to take action surrounding the election. Tell us about those days.
Sure. Well, I was, like many people, I was deeply focused on the events going around with the election and following up to the election and post the day of and immediately days following, and I got the sense, like probably most people did, that something was not right here. And evidence quickly started coming out that there were problems with voting machines and problems with suitcases being hidden underneath tables, and just various reports of different problems. And quickly got the just kind of the gut instinct that there was something corrupt with the process. And as the days really kind of turned into the first couple of weeks, some of the initial cases started coming out in Georgia and Michigan and some of the other places, and following what they were doing. And I, of course, was familiar with Bush v. Gore and that whole case from 2000, and being a licensed attorney in Michigan, I was contemplating filing action in the state of Michigan just based on the Bush v. Gore case, where we're counting ballots one way in one county and counting ballots one way in another county. And within a month or so of the election, it was very clear that that had occurred in Michigan and probably occurred other places, but I was licensed in Michigan, and I hadn't talked to anybody about pursuing it, but in the process of formulating that plan, I was reached out and contacted by my good friend Gary Fielder, who I had had similar discussions with about the election, and we had followed the election, of course, and he advised me about what he had been talking about and contemplating as far as strategy for bringing lawsuits, and approached me with the idea of forming the case as a class action and pursuing it in Denver, because Dominion is focused here in Denver. Dominion and Denver seem to be the keystone for how all of this is kind of connected. And when you connect Facebook, who also has a presence here in Denver, and the wing or the enterprise that was formed between CTCL and Mark Zuckerberg and his wife Priscilla Chan, it really started to take shape that Denver was the place we should be focusing this case on. And it's also central geographically for the country. And we're representing registered voters from across the country. And so it's not the absolute geographical center of the country, but it's close.
So you mentioned in the response to the motions to dismiss, it was important that you specify that both Facebook and Dominion are state actors as it involves the election. Is there any other precedent out there involving state actors being involved in our elections?
Oh yeah, in fact it's very much black letter Supreme Court law that has substantiated that participation in an election is an exclusive state function. And so participants in that process, even if they're private, can be considered state actors. And there's a great case out of Texas that really kind of highlights this position, and it's a Terry v. Anderson, and it involves the Jaybird Democratic Association of Texas. And since 1889, the Jaybirds had been holding a private straw poll about a month before the Democratic primary in Texas. And the winner of the Jaybird straw poll went on to become the winner of the Democratic primary almost every time. And the issue with the Jaybirds was that the Jaybirds their only requirement for membership was that you were a registered voter in in the county, but they did not allow African Americans to participate. So they conducted a white-only election and endorsed a candidate, and that candidate almost always went on to win the Democratic primary. Well, in the early 50s, a group of African Americans from the area decided they wanted to challenge that, and they took up the case, and the district court ruled in their favor. The appellate court ruled against them, and it went on to the Supreme Court, where they ruled that even though the Jaybirds were a private association, because they were involved in the administration of an election, which is an exclusive state function, they too were considered state actors and were violating the Constitution by not allowing African Americans to participate in the process. Now that's a very easy case of discrimination to see when you're not allowing members of one race to participate. Discrimination issues in our case are a little more subtle because they're not so obvious. In our case, what we have are due process violations, which really means violations of a fair process. And everybody who participates in the election really expects a fair process. If it's not fair, there's really no point in conducting the election. So that's really what's required, is setting up a process that's fair. And so the states who are charged with setting up the election processes have been charged by the Constitution to make sure that those processes are fair. And so that's how you get into a lot of some of the other cases, like Bush v. Gore, for example, where they declared that process wasn't fair because they were counting ballots in one county differently than they were in another county. That's pretty, again, easy to see. You're treating these people differently than you're treating these people. So ours is similar. There are multiple constitutional violations in our case, and so you really kind of have to look at each actor because each actor that we have sued has committed a violation of some sort. And so Dominion, we're claiming they violated the Constitution. We're saying CTCL violated the Constitution. We're also saying Governor Whitmer violated the Constitution. So they all did different things to violate the Constitution during the election. So, for example, we're saying that Governor Whitmer improperly certified the election because there were enough anomalies or irregularities or issues that were raised beforehand that she should have done at least some sort of preliminary investigation. And so the process of certifying was really not a fair process because it was not investigated really whatsoever. Dominion is a little more complicated because theirs really has to go towards the ballot review. And everybody knows that when we're looking at the ballots and trying to adjudicate ballots, we have members of both parties there to examine, so it's free and fair and open. Well, the problem with Dominion is that when the ballot goes into the machine and it gets scanned that very first time, the machine makes a decision about that scan, and it decides whether or not that is a good ballot and can go in the bin and be counted, or if it's a questionable ballot that needs further adjudication by people. And so the ballots are divided up at that decision point by a computer with no human oversight. So the ballots that go into the bin get counted, but never really suspect. Do we know those ballots were really good ballots? We're getting reports of error rates of over 90% of Dominion ballots. So who's to say that it really shouldn't be closer to 100% that should be examined? So we've got a stack of ballots that have, according to Dominion, are good, but are they good? We don't really know because they've never been checked. It goes then, so the other stack of ballots where they say these need further adjudication, they don't actually send the ballot. They send a scanned image of the ballot. So it's a PDF file or some other image file of a ballot. And that brings up the problem with the proprietary nature of the software that runs the machines entirely. The software is in control of the computer, and so it's not a human that's making the decisions. And so that is really the flaw, the fatal flaw, I think, with the Dominion voting machines, and why really they can never be used again in another election, because there's no oversight for that very first decision.
You mentioned how the Jaybirds, that lawsuit went all the way to the Supreme Court after being ruled on twice. Do you think it's likely that even though we have that precedent, that we might end up in the Supreme Court?
I think the issues in our case are significant enough that it very likely could go to the Supreme Court. I think if we win at the lower level, I think it's very likely we're going to go to appeal and the Supreme Court. I think Facebook and Dominion would certainly be appealing it all the way up if we win. But I think counter to that, I think if we get ruled against at the lower level, I think it's similarly likely that we will also appeal. I think we've got some really strong case law on our side and some really strong facts. And as I was mentioning before, at this stage of the litigation, there's a lot of questions that are factually dependent. And that really ties the hands of the judge on dismissing a case at this stage. And so if we did get dismissed, I think we would have really good reasons to challenge a dismissal at this stage, because we haven't had the opportunity to conduct discovery, for example. So for those reasons, I think we're going to get through discovery, and at that point, when the judge is able to make a decision, I think it's either way, it's going to get appealed. I really do.